Hello, welcome to our final lecture on negligence, and in this lecture we're going to look at some defences, we're going to look at how damages are calculated, the remoteness test that we mentioned in the previous lectures, and then finally vicarious liability, which is always an interesting topic. So, first of all, defences. Well, once you've proved that you were owed a duty of care, that duty of care was broken and you suffered harm as a result, you might think that you've established your case for negligence, and indeed you have, but the defendant might come back with a certain defence. And one of those is contributory negligence. Now what this says is, well, yeah, okay, I did breach my duty of care, I did do something that a reasonable man would not have done, but actually the damage that the claimant suffered wasn't all my fault, it was partly his fault. And if that's the case, if the defendant can show this, then the court will reduce the damages that the claimant will be paid. So for instance, if the claimant should have received £100,000 in respect of maybe some personal injuries, if he's found to be 40% contributory negligent, the damages that he will get will be reduced to £60,000. Now, an example of that, I would say my brother-in-law recently was injured. He was walking to work and he fell down a pothole. And you're not supposed to laugh at that one. And he suffered some injuries, nothing major, but he injured his back and his shoulder, and he wasn't able to work for a couple of weeks. So he claimed damages against the council. And he said, well, the pothole, the road was uneven, it wasn't properly repaired, and the street light wasn't working, it hadn't been fixed, and therefore the council were negligent. And he suffered, he had to have some physio, he had to have some time off work, and he claimed for his loss of earnings, he claimed for the physio costs, and he claimed for things like his taxi fares to take him to the physio appointments. The council said, well, yeah, we agree it's our fault, but let's face it, if you fall down a hole, you're a grown man, you mustn't have been looking where you were going properly. So they said he was 40% negligent, and therefore they reduced his damages by 40% to take into account of that. So that's contributory negligence. Another defence is something called volenti. Now, this means literally, to a willing person, no injury is done. For the purposes of learning it for this exam, just learn that volenti basically means consent. And it's meant to apply to things like dangerous sports and activities, parachuting, maybe even games like rugby and so on, where you know that you are going to suffer a certain amount of physical damage as a result of the game. Now, in those circumstances, you wouldn't be able to sue the organisers of the rugby match because you have consented to a certain amount of rough and tumble going on at that game. Now, in order for volenti to apply, the consent that you've given must be voluntary. It couldn't have been sort of forced from you under duress. Even a case where a policeman on duty was injured trying to catch a runaway horse that was a danger to pedestrians in the town. He claimed damages against the owner of the horse for negligently tethering the horse. And the owners said, well, we didn't ask him to chase it. He was volenti. He chose to chase the horse. He consented to the injuries he suffered. And the court said, no, that's not genuine consent. That's not voluntary consent. He was doing his job. The next point there, knowledge of the risk is not enough. You have to go further than that. So, for instance, in a case where a worker was injured when he was working in railway footings, he knew that a crane was operating over his head. He knew that something could fall off that crane and could hurt him. But the fact that he knew this could happen didn't mean he consented to a rock being dropped on his head. That's a completely different thing. So the consent must be voluntary, and you need more than just knowledge, you need consent. Now, whenever you have some sort of contractual relationship, it's quite likely that there will be exclusion clauses around. Now, exclusion clauses also arise against a claim in negligence. And where the Unfair Contract Terms Act applies, then volenti doesn't go any further than the Act would go. And you'll remember there that the Act says you cannot exclude liability for death or personal injury in a negligent situation. And therefore, volenti won't do that either. And underneath there is a little note about exclusion clauses. Again, just repeating what we've already said. you cannot exclude liability for personal injury or death caused by negligence, but other types of damage caused by negligence, we're looking at the reasonableness test. Okay, so we've looked at a couple of defences. What about these damages then? How are we going to calculate them? Well, you'll remember that the purpose of damages in tort is to put the claimant in the same position as if he had not suffered any loss. So in the case of my brother-in-law, it was all his out-of-pocket expenses and his loss of earnings as a result of him falling down the hole. Now, in order to claim damages, the key test is something called remoteness. The damage suffered mustn't be too remote. And it is worth noting this, I have seen an odd question on it, that if you actually deliberately cause harm to someone, if you do something that you intend to hurt them, then any consequences of that will never be too remote. So imagine that you loosen your friend's brake cable, intending for him to fall off his bike, and actually he falls off his bike but causes a huge car pile up and lots of people are injured, then unfortunately you're going to be liable for all of those consequences because you did it intentionally. Now, in order for you to recover for your loss, it must be reasonably foreseeable. Now, this is a bit of a strange test. The type of damage must be foreseeable, i.e. personal injury, property damage, something like that. But the how it comes about does not need to be reasonably foreseeable. It's enough that you know somebody might get hurt, you don't have to know exactly how they're going to get hurt. And the lead case here is a very famous case called the Wagon Mound. Now, in the Wagon Mound, a ship was being fuelled in Sydney Harbour, and due to negligence of the ship owners, oil was spilled into the harbour. Now, it drifted into the harbour and around surrounding wharfs. Now, as luck would have it, one of the wharfs was being repaired, and the owners were operating welding equipment. Now, they stopped the work straight away and they went away to take some advice. Was it possible that by welding on this wharf they could cause an accident, they could cause an explosion? The advice came back, no, oil on water cannot catch fire. However, it did. Due to a freak situation, a spark fell onto a piece of sort of cotton waste in the water, that burned very hot and that caused an explosion. Now, actually in this explosion a lot of ships were damaged, as was the wharf. Now, the wharf owners sued the charterers of the ship for causing the oil spill in the first place. However, they failed. And the reason they failed was that it was not foreseeable that there would be an explosion. Fire was not a foreseeable type of damage. Pollution was foreseeable, and any claim relating to pollution damage as a result of the oil spill would have succeeded. But the actual explosion and the fire damage was not. Which always seems quite harsh to me. But then you have to remember that in this case, the owners of the wharf were bringing the case. Now, if the owners of the wharf had shown that fire was a foreseeable risk, then they shouldn't have been welding, and therefore they would have been contributory liable. So it was a difficult case for them to try to win. Now, another point which we will see more of when we look at employment law is vicarious liability. Now, vicarious liability means that one person can be liable for the tortious acts of another. Now, there's three situations when this can happen: employers and employees, principal agent and partners. The main one that you're likely to see is this first one, although we will have a word about all three. Now, what happens here is quite a useful thing to have because, first of all, it protects employees. It says that if you're an employee and you do something wrong whilst you're at work, you will be protected. You won't be liable for that, your employer will be. It's also quite helpful for the claimant because usually the employer has more money than the claimant, particularly if you're suing, say, a council employee or something like that. Being able to sue the employer, the council or the government is going to give you a much more chances of achieving a successful payout. So, in order for vicarious liability, what do we need? Well, let's focus on the employee relationship first. You need to be an employee. It's very, very unusual for vicarious liability to apply in the case of an independent contractor. It can, but you need very specific circumstances. So that bit there is very rare. Also, and this is key, the employee must have been acting in the course of his employment. So, first of all, what is an employee? Well, this is something we're going to look at in Chapter 11, but it is just worth mentioning here. The tests that the courts will use differ slightly depending on what sort of point of law they're looking at. If they're looking at, say, a tax case, or they're looking at a vicarious liability case, or they're looking at an employee rights case. So just keep that in mind. The second test is that the employee, is acting in the course of his employment. Now, this phrase here is pretty important because in order for your employer to be liable, you must have committed this tortious act, this negligence, let's say, whilst you were carrying out your employment duties, not on what we call a frolic of your own. And here are some cases that tell you how that might work. Again, remember how the examiner might test these. He's very likely to pick up on the fact pattern in one of these cases and replicate it in a multiple choice question. So the lead case at the moment is this Lister case. And this is quite sad. It's the warden of a boarding school. And he was being sued for sexually abuse. Well, the boarding school were being sued because the warden had sexually abused the children who lived there. And the case turned on whether or not the school could be vicariously liable for these acts of the school warden. Now, obviously, they didn't employ the warden to abuse the children. They employed him to look after the children. Now, the courts looked at all the facts and they said, yes, the school was vicariously liable because the fact that his job was to have such a close relationship with the children, to look after them on a day-to-day basis, this was so closely related to that it was reasonable for the employer to be liable. In another case, the Dubai aluminium case, we have an employee solicitor and he drafted fake agreements and got his clients to sign them, effectively stealing from the firm's clients. And again, when the clients sued the firm, they said, well, we didn't employ him to draft bogus legal agreements. However, again, the courts looked at the fact and they said drafting these sorts of agreements was exactly within the ordinary course of his duties. The fact that he did it dishonestly doesn't help the employer. The employer was still liable. So it's whether this is your normal job, not whether doing it in this way was part of your normal job. Now, this final case, I don't think you're going to get tested on this, but it's quite an entertaining one. In this case, the Attorney General was being sued, and basically he was being sued as the representative of the government in the British Virgin Islands. So it was really whether the state was liable for the actions of a policeman, and again, the state being the employer of the policeman. Now, in this case, a police constable was on duty, and he fired shots at his girlfriend and her main companion, and also, as it says there, a tourist. Now, again, the claimant said, well, he's acting as a policeman, he was on duty, therefore this was in the course of his duties. But the courts in this case said, well, no, what he was doing at that moment was nothing to do with his police duties. It was a personal vendetta, therefore, if you like, a frolic of his own. Therefore, the employer was not vicariously liable. So an interesting one there. Now, I said we'd mention agency, so just quickly. A principal is vicariously liability for a tort committed by his agent, but again, he has to be acting within the limits of his authority and carrying out the acts for which he was appointed. And the case on there, again, I think it's unlikely you'll get a question on this, and if it does, it should be quite simple. But the case here was a car owner who asked a friend to drive his car to Monte Carlo to take part in a rally. On his way there, the friend drove the car negligently and caused damage to the claimant's bus. Now, in this case, even though the owner wasn't in the car with the friend, didn't tell his friend to drive negligently, he was still vicariously liable for the friend's negligence. Okay? It doesn't matter that the friend was going to Monte Carlo to have a holiday. irrelevant. The fact is he was driving the car as requested and he caused the accident. Final situation when vicarious liability might arise, is a partnership. Again, we'll come back to the partnerships in more detail in chapter 11, but basically, if you are in partnership with someone, then you are liable for any tort that they commit during the ordinary course of the business of the firm, or anything they do with your authority. So if your partner, on his way to a meeting, runs over a pedestrian, it's quite possible that you might well be liable for his actions there as a member of the partnership. So be very careful who you go into partnership with. Now, to wrap up this chapter, I have a question there for you to have a go at. Pause the recording and have a go. Okay, so you're ready to go. Claudia then is a trainee accountant. She meets Daniel at a party and they date for 3 months. That's nice. During that time, Daniel asks for some tax advice. Claudia looks up some information at work, but goes home and gives him advice based on that information. She's got it wrong. She gives Daniel incorrect information. A reasonably competent accountant wouldn't have given him that advice. So if Daniel decides to sue, what is the situation? Well, first of all, can she say she was merely a trainee and therefore the standard of care that she requires to exercise is lower? Well, the answer there is clearly no. You'll remember we talked about a learner driver, didn't we? Second point then, she's in a relationship with Daniel. Therefore, there's a rebuttable presumption that she didn't intend to create a professional relationship. That is the examiner trying to confuse you, because we know that rebuttable presumptions are nothing to do with the tort of negligence. That is a contract law position. So that particular position is no as well. Part C though, what if Daniel had intended to do as she advised anyway? So he wasn't affected by her advice. That is relevant to negligence, isn't it? Because that is the Book 4 test. That's very similar to the jib fastness case we looked at. If we took away her negligent advice, would he still have suffered the loss? Well, if that is the case, then that would be a defence to Claudia. Now, who is Daniel going to sue? Well, if he does manage to make his case, then he's going to be looking at suing Claudia because she provided the advice. What about Claudia's firm? Could Claudia's firm be vicariously liable for Claudia's acts? Well, the key words here are up here, look. She goes home and gives him the advice. She doesn't do it in the course of her business. He's not a client of her firm. Therefore, Claudia's firm would not be liable here. And therefore, the answer to F has to be no as well, doesn't it? Because we already know that her firm aren't liable. Okay, so that brings us to an end of this chapter on negligence. I hope you've enjoyed it. It's quite an interesting topic. Have a go at some of the questions and you'll get a feel for the sort of question you'll get. In a multiple choice paper, the questions have to be relatively factual or they have to mirror one of the cases that we've looked at. So hopefully you won't find them too testing. But if you do have a problem and you need help, contact your tutor.